For the first time in American history, the Supreme Court ruled that when the Second Amendment says there's a right to keep and bear arms, that means a right to carry a handgun outside the home for self-defense.
Context of
the
where
court
we are
struck
in this
down a
country
New
after
York
a
law
number
that
of mass
required
shootings,
showing a special need beyond a general desire for self-defense to get a permit for carrying a concealed gun in public.
Apparently,
6-3, the court said no unconstitutional.
In 2022, the Supreme Court ruled that New York's May issue concealed carry law, also known as the Sullivan Act, was an infringement upon the Second Amendment. Scores of gun-owning New Yorkers were pleased with the news, believing now they could exercise their right to bear arms with relative ease. But it wasn't long before many would insist very little had changed for the better. I was informed of a Tioga County resident named Jack Strickland, who claims that he was denied an unrestricted pistol permit for no legitimate reason. I wanted to know more, so I contacted Jack, and he agreed to a phone call interview. Hey, Jack.
Yeah.
Hey, I spoke with you earlier about the pistol permit, and I just wanted to call back and hear about essentially how everything started and came to be.
Yeah, sure. Well, basically, everything happened back in July of last year. That was right after the Supreme Court's Bruen decision. I went down to the Tioga County Sheriff's Department to drop off my pistol permit application. Like I told you last time, the process is very lengthy. It involves filling out paperwork, finding 4 references who also have to fill out paperwork. You have to take a safety course. You have to get fingerprints photographed, pay over $100, which is non-refundable, and then you have to wait for a judge to make his decision. I waited 11 months, and then I received a letter from Judge Mark Young stating that my permit had been denied.
Okay, and so what would be, do they provide any reasons as to why Mark Young denied your permit?
In the letter that I received, he said that it was denied because I had attempted twice, many years ago, to obtain a pistol permit, and both times the application was rejected. This was despite the fact that I have no criminal convictions or anything else that prohibits me from purchasing or possessing firearms. I actually own many. I have quite a few rifles and shotguns. But prior to the Bruen decision, a judge in New York could deny a permit for any reason at all. The judges who were involved with the first 2 denials were Judge Vincent Squeglia and Judge Joe Cawley. And really, they had no legitimate reason to deny my permit. And on a side note, if you want to see something really funny, just do a Google search for Vince Squeglia. See what shows up.
In 2012, Judge Vincent Squeglia was censured by the State Commission on Judicial Conduct. The panel took issue with him approving his own unrestricted pistol permit in 2005, and also negligently discharging a revolver in the Tioga County Courthouse in 2010. The latter incident was investigated by the Tioga County Sheriff's Department. Official documents show Squeglia did not receive a ticket or a summons, despite violating a local ordinance, nor was any attempt made to revoke or amend his pistol permit.
Yeah, the whole thing is kind of amusing, I guess. The guy who first denied my permit illegally approved his own. Then he fires off a gun inside the courthouse. You know, Squeglia is a moron, but Joe Cawley, in my opinion, is far worse.
Prior to being elected as a Broome County Judge, Joseph Cawley worked as a private practice lawyer. His most prominent client was Tioga County businessman Cal Harris, who was charged with the murder of his wife in 2005.
Cawley had a major reputation for being a totally incompetent lawyer, and to this day, I have no idea why Cal Harris hired him. The prosecution's case was entirely circumstantial, and Cawley could have easily won. There was no confession, no witnesses, no murder weapon. Most important of all, there was no body. And yet Joe Cawley lost. He could not convince a jury of Cal's innocence. And as a result, Cal Harris temporarily went to prison.
Harris eventually hired different lawyers. His conviction was successfully appealed, and in 2016, he was acquitted of murdering his wife.
There was definitely some corruption by the local DA and the state police, and my understanding is that Cal Harris is currently suing them. But it doesn't change the fact that Cawley was horrible at his job. You know, this whole thing reminds me of a statement I heard from a very prominent lawyer named Charles Peruto way back in the day. He said that murder cases are some of the easiest to beat, especially when there are no witnesses.
Murder is the easiest case to beat of all because one witness never shows up and testifies against your client in a homicide case, and guess who that is?
The dead person's dead.
Yeah. If you sell drugs right to the narc and you get an acquittal in that case, then you did a real nice job. If you represent a murderer and there's no witnesses and you get him off, big deal.
This is all relevant to the issue we're discussing because it shows that sometimes men in positions of power have a very long history of negligence and incompetence. And sometimes those men can determine whether or not we get to exercise a constitutional right.
So Squalia and Cawley both denied your application, despite the fact that you don't even have criminal convictions. Now what reasons did they have in their arsenal to stop you from securing a permit?
Well, there's an incident that has been used against me, I would argue unjustifiably. It occurred well over a decade ago. It all stems from when some scumbag by the name of Darren Martin tried to pull off a robbery in my home. And as a response to that, I did what any reasonable person would do. I shot him in the stomach. I was arrested and I was charged with felony assault, all because I shot a man who entered my home and tried to rob me. See, that's how New York operates. If you defend yourself against a criminal, you can suddenly become the criminal. And my story is not some isolated incident. I can point to numerous examples of people who face really obscene charges simply because they were defending themselves against muggers or burglars. And sometimes these charges are dismissed or they win in court, but the fact still remains their lives are inconvenienced, or they have to spend thousands or sometimes millions in legal fees.
New York penal law clearly states that deadly force can be used to terminate a robbery. Jack's lawyer planned to argue this fact in court, but the opportunity never arose. Jack's felony assault charge was eventually dismissed after DA Irene Graven claimed that several legal factors would potentially allow Jack to prevail on justification defenses.
They knew that my actions were justified under the law, yet they dragged everything out for months. Darren Martin got exactly what he deserved, and I'm only sorry he survived. I later found out the only reason he was even living in New York was because he had a warrant in Pennsylvania for stealing science equipment from some school. And then a few years later, after the shooting, he was arrested for a sex crime.
Following the dismissal of the felony assault charge, Jack and his attorney held a press conference at the State Police Barracks in Owego, New York. Jack's rifles and shotguns were returned, and he was interviewed by the local media.
So here's the deal. I used a firearm in self-defense to protect myself against some violent thief. I was then charged with a felony, which was ultimately dismissed. The DA herself admitted that I acted in self-defense, and yet just having that charge on my record can be used against me when I apply for a permit. The investigator who reviewed my applications the first two times actually admitted to that in a 2014 phone call.
Anything that is on record, any complaints, even there's no arrests, doesn't matter how it comes about, anything on file in a negative manner can be used against you. There does not need to be any convictions, nothing like that. The application specifically asks, have you ever been charged? They don't even ask if you've ever been convicted, because once you've been charged for something, it's up to myself or whoever to gather more information on that to try to find out how it was resolved.
Well, you should have known then that it didn't result in any kind of criminal conviction.
That's why it shows that you were discharged and not ever convicted.
People often ask why I don't just leave New York. They tell me I should move to a more gun-friendly state, somewhere like Texas or Florida. I hate that. That attitude is such cowardice. This is my home. Why would I leave? You know, I have been here my entire life. I plan to die here. I'm not going anywhere.
Towards the end of our conversation, Jack made it clear that he plans to file a lawsuit, known as an Article 78 proceeding, to challenge the denial of his pistol permit. He is currently using a GoFundMe account to raise funds for his legal fees.
What really offends me is just the sheer arrogance of Mark Young. This clown is just some podunk Broome County Judge, and he thinks he can openly defy the Supreme Court. People like that need to be taken down a notch, and I'm going to fight him every step of the way in the legal system. I will do whatever I have to do. I will raise funds. I will file appeals. I don't care. If anyone can find an attorney willing to work for free, I would have no reason to ask for money. I would delete the GoFundMe. All I want is to exercise my constitutional right to carry a handgun for self-defense. But I can't legally do that without a permit, so I have to take this matter to court. And unfortunately, lawyers are very expensive.
What happens next remains to be seen, but my intention is to follow this story and provide information regarding any and all new developments.